Dr. Bagai, I know your hand is up. I'll allow you, but Aditya Pratap has been waiting on this panel. Let me just go to him. Aditya Pratap, to what Mr. Ashwani Dube has spoken, let me just ask you this question. There is a new act in place, there's a new law in place, but there's also precedence of Supreme Court's judgments. And out of Supreme Court's judgments, it has been established that if there is medical negligence suspected or preliminary found, there has to be an expert panel that will then look into it. So while you have the BNS or the new criminal law, which states that there is criminalization of medical negligence, to establish that or to reach that conclusion based on a suspicion or a complaint that may emerge, wouldn't then the precedence of Supreme Court's judgments about medical panels also be reflective in it about how it is seen on ground, how it is implemented on ground? Isn't that how it will go forward?
Well, the Supreme Court of India in 2013 passed a constitution bench judgment in the case of Lalita Kumari versus State of UP. In Lalita Kumari versus State of UP, the Supreme Court held that when the facts prima facie disclose a cognizable offence, an FIR can be registered. But in certain cases, a preliminary inquiry is necessary. And one such instance was medical negligence. Honorable Supreme Court held that when medical negligence is alleged, especially when it's a case of latent medical negligence, like medical negligence is of two types, patent and latent. Patent is like leaving a scissor inside the person, feeding a person a poison instead of a medicine. That does not need any application of mine. But when it's a case of latent medical negligence, when a person has to go into the merits or demerits of a technical decision taken by a doctor, then Honorable Supreme Court held that in such cases, there has to be a preliminary inquiry. Now, the biggest concern with Section 106 of the Bhartiya Nyaya Sanhita is that it probably does away with the requirement of a preliminary inquiry. Now, let's come to say, I would like to say for a fact that there are three kinds of professionals a person deals with in his lifetime: lawyers, doctors, and bankers. Bankers, if they go wrong, they will face maybe IPC 409, which they rarely do. If a lawyer goes wrong, he only faces bar counsel disciplinary proceedings. But if a doctor goes wrong, he will face consumer case, police FIR, as well as a misconduct or disciplinary inquiry with the medical commission. So which is why, and doctors perform the toughest task, which is why it is all the more necessary that the law should have had an inbuilt safeguards to protect medical practitioners. Do you know what happens when a medical practitioner undergoes disciplinary proceedings? His peace of mind gets destroyed. He's unable to treat other patients. And let me just tell you, when in the amended Prevention of Corruption Act, you have put in 2233 levels of protection for corrupt public servants, why did you not put in protection for doctors? So yes, the Bhartiya Nyaya Sanhita in its current form is vulnerable to, excesses, but I do hope that the concrete precedents laid down by the Supreme Court of India. I don't even think we need to
get down doctors to compare them to the level of politicians for that matter. But Ashwani Kumar, the panelists here really is saying that they need an environment for protection. They need an environment where they can perform their basic duty without fear. But so are we essentially then worried and looking, the way there's no doctor, even one doctor who came out in support of this law. There have been protests after protests for the last several months. The Home Minister did make a statement in the Parliament about this as well. Have we overlooked what may have been the intent and what might be the result of this law?
What has come now? Nothing has come now. Why? The act of misconduct, the abuse of professional position was already defined way back. The Supreme Court and various other forums have already decided. Not taking the consent of the patient. Why? The mens rea is important, intent is important. As I cited the example of a Lucknow patient, you have also gone through that. If not, then I will share. Violation of regulation laws are already in place. The medical professionals must follow the rules and regulations regarding the duties and responsibilities laid down in the Indian Medical Council. They just called the Professional Conduct Etiquettes and Ethics Regulations. Right to know the information. The doctors must inform the patient that, look, this critical disease or critical illness you have, and these are the procedures which are to be followed. 1. 2. Right to see and check records and report related to their ailment. 3. right to receive medical care during an emergency. These are the components. And if there is violation of regulation and laws, if there is a negligent act, then only section 106 will come. As I said, it is very much written in the 106. What is it? Whoever causes death of any person by doing any rash or negligent act not amounting to culpable homicide shall be punished with imprisonment of either description for a term which may extend to fine. 5 years of fine. Means by doing any
all right.
rash negligent act. How do you justify? It's not policeman is going to justify. The act of the doctor itself, the procedures given on the summary, the medical summary, and they are not in consonance with the medical jurisprudence, then only this section will apply. Why don't you want to check and balance? That is the question here.